Okay, perfect.
Um,
Excellent.
or I
All right,
could
well,
a moment ago.
okay, well, thank you all for joining us. We really appreciate you bearing with we had some minor technical issues, but now we're all here. We're really grateful for y'all joining us this afternoon. My name is Daniel O'Neill. I'm a partner in the Houston office of Thompson Co. Cousins and Irons. I'm also a trustee on the Houston Young Lawyers Foundation board. I help run the CLE program. So I think we've assembled a fantastic panel here today. We're here to talk about legal malpractice 101. This is kind of a nuts and bolts presentation about how legal malpractice claims and litigation is working. So I guess to introduce myself, I've been practicing for 15 years. I'm a partner. I was honored to be named to the best lawyers to ones to watch for in professional malpractice law. Joining us here on the panel, we have Kamy Schiffman. She is a senior counsel here. She's been practicing for 25 years. The last case that Kamy and I worked together on, and we just got a really good result in this about a week ago. It was a case out in Henderson County. I took one deposition, and then Kamy assembled this monster and savage motion for summary judgment. One of the best ones I've probably ever seen. And it was so intimidating that the plaintiff just went ahead and non-suited the entire case rather than even trying to file. Okay.
Everybody can mute their microphone. That'd be great.
And then rounding out the panel, we have Gabriel Garcia Gonzalez. He is a 2024 law graduate. When he was in law school, he clerked with Judge Miller in the 190th. In law school, he was a moot court advocate. He was also the articles and notes editor for the Journal of International Economic Law. So rounding out our panel, you're going to be hearing from a junior associate, a partner, and then senior counsel. So we're trying to provide a variety of different perspectives, and we really appreciate y'all joining us here. The HYLF CLE program is something I'm very proud of. We've made some big changes to it over the last couple of years. So if you enjoy this, hopefully you will join us for some of the other upcoming CLEs we have through the end of the bar year. So, all right, let's go ahead and get started. All right, so why are the three of us presenting on Legal Malpractice 101? So all three of us practice in the professional liability group here in Thompson Co. So what do we mean by professional liability? So the types of claims that we're looking at are usually dealing with some kind of licensed professional. So lawyers, accountants, financial advisors, doctors, we have directors and officers in both nonprofit and for-profit organizations. We see realtors, brokers, we see insurance agents and brokers. We see the entire spectrum of architects, engineers, construction, designers. We see a lot of surveyors. And then there's a bunch of other claims that are something of a miscellany that still are going to fit within the professional liability group. So we were talking about who we think is the most likely person that's going to be dialing in today for the CLE. So we think the audience is likely going to split maybe three different ways. The first kind of group of people who might be tuning in today, you might think that your friend has potentially committed some kind of legal malpractice and you're urgently trying to learn something. That can be some Googling, that can be some Westlaw, that can also be just trying to talk one-on-one with people who maybe know a little bit about these, especially on the defense side. Another kind of core group of people that we're expecting maybe tuning in today are just the naturally intellectually curious that are interested to learn about how these kind of claims work. A lot of these kind of claims are in the news, especially the more high profile ones, especially in California and New York right now. And then kind of as a subset of that group, the intellectually curious, we're expecting to see that maybe there are some people currently in some type of litigation practice in another practice area, and they're actually thinking about maybe trying to switch over more to this specific practice area of professional liability. We're a professional liability group. This quote from Mark Cuban has always kind of stuck with me since I heard it a long time ago. And I think that is really a good way to kind of think about some of this. When we are defending licensed professionals, they've worked very, very hard. Medical school, law school, graduate school. They've worked to build their business, build their reputation. And then Mark Cuban's quote comes in is you have to think about all these people at kind of the apex of their success, that there's plenty of other people on the other side that are coming after them. And that is why it's such a rewarding practice area to be on the defense side of these kind of claims, because you are able to step in and there's all these kind of salacious allegations that the other side is making. And it's your job to kind of be step in and against allegations.
These are all things. I don't.
All right.
Please mute your microphone for all participants. Thank you.
Right. So the bar journals that we all receive and occasionally read and occasionally use them as a doorstop or to help level a table. This is something that always stood out to me. This is from, I think it's 4 or 5 years ago. That was the first time I saw this. This is from a marketing advertising perspective. It's designed to be sleek. It does not provide you 100% of the information, but just from a general overview, it's very helpful to kind of look at these things. So, the ad is about, it's a family law claim. The lawyer was sued because they didn't win their child custody case. This is the difference between if you're covered by insurance or not. So the person that was covered by the specific policy written by TLIE, and this is not an advertisement for TLIE. This is not an advertisement for any specific carrier. This is probably more an advertisement than anything, just to make sure you have insurance rather than you do not have insurance. This ad splits out what the kind of defense costs were in just this very specific claim. You have to keep in mind, this is a pretty old claim. So there's a couple things I'm going to run you through over the next couple of minutes, just talking about why claims on legal malpractice, why expenses on legal malpractice claims have been rising so much, some of the factors that are contributing to that. So $67,000 4 or 5 years ago, that's going to look a lot different these days. Something to keep in mind as we're going to go through the rest of the presentation, something to think about is where is the dividing line, and is there one? And if there is, what are some factors that might tilt it one way or the other between whether it is a legal malpractice suit you need to worry about or a grievance? So while they're related, they're two very distinct things. Kamy has most of her presentation is going to be on that, so you're all going to be talking about this in a lot more depth in a couple minutes as soon as I turn it over to her. But kind of, just as an introduction to get you all thinking about this. So a legal malpractice claim in Texas requires 4 elements: duty by the lawyer to claimant, lawyer's breach of that duty, proximate cause, and the damages. So the important thing to be thinking about are their financial damages. We do have 0.5 ethics for y'all today. So you're going to be hearing about ethics peppered throughout the presentation. So first part, we're going to have you, just kind of think about in the back of your mind, the preamble to the TDRPC. If you haven't read the preamble since you took professional responsibility, sometimes it's good to just kind of go back to it and think about it. The way it's written, it's inspiring, and it is always helpful to kind of go back to, why are we lawyers? Why did we put up with 3 years of law school, the bar exam, all of that? And just the last 2 sentences really kind of make you think about what a noble profession this is. It's its greatness and strength, which permit of no compromise. So this presentation is not going to be legal advice. as you all know, facts and circumstances greatly depend. We can't give anything beyond just kind of general discussion points, things that we think are interesting. So while it's not legal advice, typically, you can write a spicy email, but you should probably never send it. Just something to keep in mind. That's from a practical perspective. That is not legal advice. Okay, so generally speaking, this is obviously overly simplistic, but it's a way to just kind of intellectually start thinking about how claims get evaluated when they come in. So this is kind of an overly simplistic XY axis. There's always going to be a potential exposure we're thinking about as these come in. Are they asking about things that they're never going to get, and the potential exposure is relatively low. It's all coming down to what the financial damages are, kind of what the case looks like, a lot of these other soft factors that we need to kind of just think about and figure out, which really distinguishes, your garden variety kind of claim versus one that's a little more sophisticated and has a lot of different moving parts, and it's just going to require more time to really kind of figure out what is going on in the claim. And then, the allegations, they range from very believable and there's video of whatever they're saying happened versus things that, just kind of are going to stretch the imagination a little bit. And from the plaintiff perspective, they're maybe going to have a little more difficulty trying to prove what some of these allegations are. So one of the results I'm probably most proud of on my legal malpractice defense, history and jacket that I have. There's a specific claim that I was hired into. It had been going for a while. The original offer made to the claimant when the claimant was pro se was insane how large that number was, and that pro se claimant turned it down because the pro se claimant was pro se, didn't necessarily know what the claim was worth, and potentially had received some bad advice through Google University. So then we went through the whole litigation process, aggressively litigated it, and then once we got to mediation, that claimant who had in the interim went out and hired a lawyer on contingency, so giving up 43% plus expenses to the lawyer. Settled for significantly less than had been offered for pre-suit. So whenever we look at this XY axis, there's always that kind of consideration that somebody can think it is a very strong claim and that they're going to get the mega bucks, but that's not always necessarily what's going to happen once it gets into litigation, once we take some depositions, do some written discovery. So that is kind of the art to these, and that is something that is significantly impacting why claim expenses are rising so much. So that is a pretty good segue why malpractice insurance is getting more expensive year over year. So historically, conceptually, this makes sense. Whenever the economy is bad, more claims are going to get filed. That's just an obvious. Some numbers that are probably somewhat scary if you don't practice in this area, and you may have never heard this before. Roughly 4 out of every 5 lawyers will get sued for malpractice at least once in their career. Wow. 70% of claims are filed against solo small firms of less than 6 lawyers. So that's obviously not saying that larger firms are never going to see kind of claims. But just the numbers by themselves typically tell you, the heat map is if you are a solo or you work in a small firm of less than 6 lawyers, you are carrying the super majority of claims. So since it is early January, we do not have numbers in from 2024. So the most recent full year that I can talk to you about is 2023. So these are also some very interesting and very large numbers that, if you don't practice in this area, you may have never heard this kind of stuff before. 70% of legal malpractice carriers paid out over $50 million on a single claim. That's not how much they paid out the entire year. That's a single claim. And there are a lot of claims that every carrier is seeing. More interestingly, 3 specific carriers paid out over $100 million on a single claim. And then beyond that, 2 carriers paid out up to $300 million on a single claim. So these are some things you need to keep in mind. We're not talking about 30-60 policies and MBA cases. We're talking about significant money. So the question I get asked most often, where are the claims trending? And that's usually even what we're going to call the CLE presentation, what's trending in professional liability. So we went a little different on the naming this year, but the three practice areas that are getting lit up left and right currently are trust and estates, business transactions, corporate securities law. When you think about it, I mean, it kind of makes sense. The trust and estates area is rife with both deep emotion, the loss of somebody or loss of somebody's faculties, if it's a guardianship kind of case, financial anxieties, especially when the matriarch, the breadwinner of the family is gone or otherwise incapacitated. The trust and estates area really kind of brings out that keeping up with the Joneses mentality of most Americans like to compare themselves to other people, and they want to know how they're doing relative to others. So, if they don't have the Rolex and the beach house, they're not happy. And when they're not happy, somebody else is going to have to pay for it. There is a huge issue with income inequality and a lot of very unequal recovery that has happened as a result from the pandemic. You can read plenty more about that. It's just something to consider that in a lot of claimants, there's going to be a lot of kind of feelings of redistribution of wealth and things like that. So there's no one single reason why claim expenses have accelerated so much. It's a variety of different things. Some of it is just kind of temperamental, psychological things that are happening on the claimant side. It's a lot of bigger factors that are happening in the economy that you and I have no control over, like what the mortgage rates currently are and how people are feeling stretched at the grocery store and other areas. And then one of the wildest claims you'll probably ever hear about this is a business transactions, contract negotiation type of case. Two white shoe law firms, two of the biggest firms in the country, received a massive legal malpractice claim where their client was suing for over $300 million because in one of the contract documents, the word was written as buyer rather than buyers. So, in those huge kind of cases with corporate securities law, business transactions, these are going to be huge discovery, metadata, document productions requiring experts, and they're going to get incredibly expensive. In terms of mitigating risk, one of the worst things you can do in your practice right now is using AI. Conflicts of interest and drafting areas are the other two areas that are the most significant areas of very easily avoidable claims. Using checklists, doing a final look at whatever draft document you're sending out. If you had written buyers rather than buyer, you would have avoided that $300 million claim. Additionally, some carriers are trying to figure out how to get some of these claims settled very quickly. So, an interesting thing that has been, attempted, and not every carrier is trying this, only specific ones are, they will entirely waive the deductible for the insured if the claim is settled within 60 days. So in cases where there is an eroding policy, which is going to have separate issues by itself, waiving the deductible is a way to get a lot of these settled pretty quickly. So, that's just something that carriers are starting to look at. There's going to be a variety of other things that get deployed over time. So a word about AI, just because everybody's talking about that. So I got this email at 3:50 a.m. yesterday. I found it very interesting because I'm one of the people that is very cautious about AI and do not think in its current state should be used in practice by anybody. Stanford AI expert was torn apart by a Minnesota federal judge because something that got submitted was completely rife with completely fake AI generated sources. So that is not the first one of these. Multiple federal judges around the country have they standing orders, do not submit anything written by, generated by, anything dealing with AI. Most law firms that are, 6+ people around the country are implementing rules and requirements that their lawyers are not allowed to use AI in any aspect of the business. AI is a significant risk right now. The technology is just not where everybody thinks it should be. There are huge confidentiality, data privacy issues, and that's not even the biggest one. You know, as we talked about from the headline the other day, there are fake sources that are getting introduced into these AI-generated briefs. That's causing huge problems. In nearly all, but not every case, you need to disclose whether AI has been used to generate any of the, you know, briefs, motions, client work product. Beyond the fake sources, there's also a poor quality work product. If you've seen any of these things generated by AI, you can typically tell when it's been generated by AI. I mean, that's a very easy way to get sanctioned. So, you know, generally speaking, this is probably not something you want to do until the technology gets a lot better and catches up with, you know, convincing federal judges that this is an okay thing to be doing. So I'm going to run you through some ethics stuff real quick, and then I'll pass you over to Kamy. Rule 1.13. Lawyers typically like to get involved in the community, nonprofits, volunteering. That is always a great thing. There are ethical rules. 1.13 is something you should definitely look at if you're going to be volunteering as a director of a 501c3, C6, something like that. Always read the comments. That's probably one of the most important things I can recommend when you're reading through the rules. In summary, if you can't be good, be very, very careful. Nobody wants to get a legal malpractice claim and or a grievance. Kamy is going to talk to you in more detail about kind of where that dividing line is. Last but not least, since you know, of the three kind of groups that we're expecting to be here today, I was primarily talking to the intellectually curious who may be thinking about trying to, you know, maybe practice in this area. So who does well in a professional liability practice? If you enjoy puzzles, you are a good storyteller, you're a lifelong learner, you want to be a trial lawyer and actually go to trial rather than just calling yourself a litigator. If you're active with pro bono volunteer service out in the community, so you have lived experiences of the impact of, you know, some of these things on people's lives, especially if you have prior experience in a professional area. For example, me, I have a tax LLM. I did tax controversy and litigation before I transferred over to this practice area. You know, somebody with an accounting background, something kind of quantitative, that is going to be an ideal fit for our practice group. So since I'm talking primarily to young lawyers, law students, if you have any interest in professional liability, especially on the defense side, I'm more than happy to talk to you in a little more detail. Obviously, you know, if you have some litigation experience, it could be a very interesting discussion. So I want to thank you all for joining us for this portion of the presentation. I'm going to kick it over to Kamy, who is going to talk to you about grievances, ethics, and a whole bunch of other stuff. Thank you.
So good afternoon, everybody. I'm Kamy Schiffer, and I am primarily going to be talking about the distinctions between legal malpractice and ethical complaints or ethical violations, or to be technical, violations of the Texas disciplinary rules of professional conduct. My firm, one of the things we do in our section, Daniel and I and Gabriel, is we also represent attorneys in defending a grievance filed against them. None of what I'm about to share with you is based on real stories. Just FYI, they're a fact here, a fact there, but none of them are exact, naturally to protect client confidentiality. So first, I'm just going to reiterate. I hope everybody can see my screen. Daniel, can you see it? Okay. So Daniel hinted on this already, but elements of a legal malpractice claim, they're the same elements of a negligence claim. Duty, breach of the duty, and proximate cause of damages. But I wanted to display this case, Rogers versus Zanetti. This is a quote, Supreme Court case from 2017. This case specifically notes that a lawyer can be negligent and cause no harm. And if there's a breach of duty, but there's no harm, then there's no valid claim for legal malpractice. It's per the Supreme Court. And then it cites a case in 2004 that specifically notes that even if you have an abundance of evidence of the breach, it can't substitute for causation, which is generally the same rule in a negligence claim. So the other component of a malpractice claim, when it arises from the results in litigation, is you have to prove the suit in a suit or case within a case. think probably everybody who has been through law school remembers this, maybe gives some degree of comfort. The plaintiff would have to prove the underlying case that they would have won or would have gotten a more favorable result. But this is just an important thing to note. Note also that this is also from Rogers versus Sonetti, but note at the end of this quote, it refers to, or it cites Elizondo v. Christ, a 2013 Supreme Court opinion. And in Elizondo, the court noted that a suit within a suit does not apply when the malpractice is negligent settlement. I'm not sure how many cases come from negligent settlement, but it's something to keep in mind. Your duties don't end, and it's still a possibility of being sued, and it's even a lower burden because the plaintiff wouldn't have to prove the suit within a suit. Okay, so I want to next talk about we'll start with some scenarios. These are merely hypotheticals for discussion purposes, but I want to give you guys just kind of some thoughts, some potential real life situations, situations that could happen, to think about it. So in the first one, Attorney Smith accepts a new case on October 5th, 2023. The plaintiff, Morgan, wants to sue the defendant because Morgan made blatantly defamatory comments, the defendant did, about Morgan at a benefit gala. Morgan did not recall the exact date when talking with Smith, but knows it was late February of the same year. Turns out it was February 22nd. So Smith's docket clerk thinks that the tort claims have 2-year statute of limitations, and calendars the deadline for filing suit as January 31st, 2025. Smith files the petition on March 1st, 2024, thinking I'm well within the 2-year statute, well within the deadline that my docket clerk filed. And then lo and behold, the defendant files a motion to dismiss under Rule 91A, which is no basis in law or fact, and gets the case dismissed because defamation cases, specifically libel and slander, have a 1-year statute of limitations under section 16.002 of the Civil Practice and Remedies Code. So the real question for us is, did Smith engage in malpractice or violate the Texas disciplinary rules, or maybe both? Let's take a look at it. So, and one question people may have is Smith responsible when it was the docket clerk that made the error, that calendared it incorrectly? Well, yes, even though the docket clerk made that calendaring error, Smith is the attorney, and Smith is who owed the duties, or the duty to timely file suit to Morgan, the client. So that would be malpractice. Missing a statute of limitations is malpractice. It might be a rule violation, but it really depends on other facts. I put in here, just for reference, Rule 5.03B on responsibilities regarding non-lawyer assistance. That, if you're not familiar with that rule, it basically says lawyers need to give adequate supervision and make sure that the non-lawyers comply with the law and so forth. That is just a very, very oversimplification, but take note of that rule. If you have staff that really don't keep on top of things, that you could end up being responsible. Okay, next scenario. Same general facts, but Morgan, the plaintiff, tells Smith, the lawyer, because Smith asked, well, what did the defendant say? And Morgan says, well, that they told their coworker that I had a hard time keeping a job, and I was only at the last one for 4 months. But I was never terminated, and I was at the last job for 6 months, not 4. I really want to sue this person because we had a previous relationship, and I'm just mad from that, and they really didn't treat me right, and I want to pursue a defamation claim because what this person said was not strictly true. Smith files a petition for defamation. Has Smith engaged in malpractice, violated the rules, or both? Does anybody want to, I don't know, can I do a raised hand with the sharing? Does that work?
Yeah, or anybody that's comfortable can come, unmute themselves and talk. It's a Brady Bunch style CLE, so y'all are more than welcome if you want to talk.
I don't know, I put a few people on mute, just to make sure it wasn't, because we had a few disruptions, so I don't know if people can do that or not. Anyway, I apologize if somebody is trying to unmute and you can't. So in this scenario, defamation, the facts are quite different, right, from the first scenario, because in the first scenario, the story was that this defendant had made blatantly defamatory comments. Like she's been fired from, that Morgan had been fired from 5 jobs, something like that. Okay, that's missing the statute of limitations. Here, though, we've got much more toned down, tampered down statements that were supposedly defamatory. But Morgan still files the suit. I'm sorry, Smith, the attorney, still files the suit, even though it's mainly driven by personal vendetta. Is that malpractice or violation of the rules? Well, it's malpractice for still missing the limitations deadline. I didn't reiterate that, but it would be either way, right? I think in this scenario, it would also be a rules violation. Now, my input on this, as displayed on the screen, it's not legal advice. It's not a real life example. It's not an absolute complete picture, right? But I wanted to highlight for our participants this rule that may not be one that people look at terribly often. Rule 3.01, meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless the lawyer reasonably believes that there is a basis for doing so that is not frivolous. And I've thought about this rule a lot since writing this presentation, and defending a proceeding is a curious one. Here, that's not where we're focused, because everybody deserves a defense in a case. I suppose the gist of the rule for defense is you can't defend and assert frivolous defenses in that kind of way. Not that the person never deserves a defense, because everybody, it's an absolute right. And in criminal cases, I'm sure everybody knows it's an absolute right to have the right to counsel. But reason I brought this is, as an example or a scenario, is it a frivolous claim when there's the statements made were really not, strictly speaking, are they even defamatory? When this person told a coworker, Morgan had the last job for 4 months, turns out it was 6 months. That's not strictly true. But also, Morgan had a hard time keeping a job, and it turns out Morgan has never been terminated. So is that really defamation to begin with? And plus, Morgan had told Smith, this is really about a personal vendetta. And so in my assessment of these facts, it looks like this lawsuit would be frivolous. So I count this as a rules violation. It obviously depends on more of the detail. Specifically, if we were looking at it as a real life case. Okay. Scenario number 3. Again, another hypothetical. This is a little more complex. Attorney Jones was claims counsel with a major insurer for more than 15 years. Jones represented the insurer in first party cases. In-house counsel can sometimes be counsel of record, and sometimes they can be the claim handler. Just FYI. At a bar function, Jones chatted with a classmate friend who asked if Jones would be interested in joining the friend's firm. During the interview, the firm's managing partner told Jones the firm routinely files cases against Jones's current employer. A week later, the partner made an offer to Jones saying, we would be happy to have inside knowledge about your employer, this insurer. Jones accepted the offer and joined the casualty section of the firm. During partner meetings, Jones suggests specific strategies on first-party cases against the former employer. Jones is not the attorney in charge on any of the first-party cases. Has Jones engaged in malpractice or violated the rules? Okay. This is one I included because I think that this scenario, when people think of conflicts or confidentiality, or moving jobs, they think of, I can go to that other firm if I'm not going to be working on the same exact case. That's true to a point. The main conflict is when you work on a case, you can't switch sides, right? Can't go to firm A representing the wife in a divorce and then join firm B and then suddenly represent the husband. That is just no way, right? An absolute conflict. But can you go from place to place when you've been there a very long time and you've acquired knowledge of how that intimate knowledge, you've become very familiar with how the firm or the company, your employer, and in this case, your client, runs things, how they respond to litigation, how they, what their strategies are in litigation. And in this scenario, as you see on your screen, Jones, the former claims counsel, was making suggestions on specific strategies on first party cases, but is not the attorney in charge. Well, for one, Jones cannot use confidential information to the disadvantage of a former client. Confidential information is not Rule 1.09. That is, at least I don't think it is. It's a conflict of interest former client rule is what the rule's entitled. So here's the rule on that. Rule 1.09C, a lawyer who has formerly represented a client in a matter or whose present or former firm has formerly represented a client in a matter shall not thereafter use information relating to the representation to the disadvantage of the former client, except as these rules would permit or require with respect to a client, or when the information has become generally known. Strategies about how an insurer handles first-party claims chances are is not generally known. Then there may be lawyers, plaintiffs' attorneys who do first-party cases that get impressions, but it's not out to the public how they handle litigation. And the other exception, the other occasion where a lawyer, former representation or former client, cannot reveal information relating to the representation except as the rules would permit or require with respect to a client. In this situation with Jones disclosing strategies, I think there could be a occasion for malpractice there too, for maybe disclosing confidential information or something along those lines. But my focus in this scenario is to explain that it's conflicts of interest are not always the same matter, the same specific lawsuit, same specific transaction. They can occur in other situations when you are just so intimately familiar, for example, with your former employer, former clients' manners of handling litigation. You cannot then switch sides or basically use that information to the disadvantage of the client, the former client. Okay. Similar facts, but in this one, scenario 4, Jones is claim counsel for just 3 years and works only on first party cases that are against the insurer. Same kind of cases, but just 3 years, not 15. Jones doesn't work on other casualty cases, for example, or other types of claims, just first party claims. And just FYI for anybody who may not happen to know, first party means that the plaintiff is suing the insurer directly, basically for not paying a claim. Classic example is there's a storm and the plaintiff thinks the insurer should have paid to replace the entire roof, and the insurer only agreed to do a partial repair. That's a first party case, or they sue for no coverage. It can be any type of coverage, health insurance, auto, whatever. But that's what a first party case is. Third party is generally casualty when there's a person external to the policy that files a claim against the policy holder, and then they tender it to their insurance company for coverage. That's third party. I'm talking about first party cases. In this scenario with Jones, he only works on those. And at the bar function, Jones sees a classmate friend, and that friend asks, hey, would you be interested in joining my firm? And Jones knows it's a prominent personal injury firm. They don't do first party work. It's just personal injury, which is third party cases only. During the interview, the firm's managing partner makes Jones an offer. Jones accepts and joins the firm. Has Jones engaged in malpractice or violated the rules in any way? I'd say probably neither malpractice nor a rules violation. Jones was only with the insurer for 3 years, only worked on first party cases, unless somehow Jones happened to become really familiar and know confidential information that Jones could use against the former client, the insurer / employer, in future cases, in the personal injury cases, which would be kind of a hard thing to prove, I would think, then it wouldn't be a violation of the conflict of interest rule on former clients, 1.09. Probably not malpractice either, because there's no confidential information being disclosed in this scenario. There's no missed deadlines. There's no actions where Jones is acting in a way that is not reasonable or prudent. And I've got here also Rule 110, imputation of conflicts of interest. I'll just go over that really briefly. I think this is the rule that that was recently amended by the state bar and by our vote, I guess, because it allows screening, and you guys probably have heard of conflict wall is a common phrase for it. And there's actually a definition of screened in the rules, which I didn't know there was an actual express definition. The definition is the isolation of a lawyer from any participation in a matter through the timely imposition of procedures within a firm that are reasonably adequate under the circumstances to protect information that the isolated lawyer is obligated to protect under these rules or other law. And the rules were modified to allow lawyers more ability to change firms, because previously lawyers had been conflicted out. I had this happen myself quite a while ago, obviously. But you can now move firm to firm if you follow all the procedures for screening. And the reason I put this specifically is this rule talks about if one lawyer is disqualified from representing a client in the firm, then all lawyers are disqualified. The rules contemplate that lawyers within a firm are going to talk, and if one lawyer is disqualified, then the other is. You can't. Now you can follow the screen, but that's basically an exception. Okay. Scenario 5. This is again a hypothetical for discussion only. Attorney Davis practices in a small town. During a holiday party at a friend's house, Davis talks with a friend about Davis's latest cases. Davis makes a few whispered comments about having an undisclosed conflict arising from representing an individual named Avery Williams, the plaintiff, in a slip and fall case in which Davis previously had consulted with ABC Corporation, the premises owner. Davis also tells the friend, and ABC told me it had never used wet floor signs. And basically Davis is whining and lamenting and contemplate what does he do. I have did Jones as a typo. Did Davis engage in malpractice or violate the rules? In this scenario, this is kind of a multi-tiered scenario. Okay. Davis violated Rule 1.05B1(2), and that's II. You guys can see it on your screen. I've got the language of the rule that this 1.05A defines confidential information and privileged information. Confidential information includes both privileged information and unprivileged information, client information. Privileged information is information of a client protected by lawyer-client privilege. Basically, I mean, that's what the rule specifically says. Unprivileged client information means all information relating to a client or furnished by the client other than privileged information acquired by the lawyer during the course of or by reason of the representation of the client. And then B2, the one I was just quoting, is except as permitted by paragraphs C and D or as required by paragraphs E and F, required by E and F, a lawyer shall not knowingly reveal confidential information of a client to anyone else other than the client, the client's reps, or the members, associates, or employees of the law firm. Remember, in this scenario, Davis just told a friend about how ABC, the client he was not representing at the time, but had consulted with as a prospective client, the information about the warning, not putting out the wet floor signs. Can't do that. I think most people know you can't disclose confidential information, right? You can't say something a client told you. That's pretty clear. But I brought this one up, created this one for specific reasons. And let me just briefly touch on, there are exceptions to disclosing confidential information. And they're displayed. There's 5 situations right there on the screen. When the client consents is number 2. The lawyer has been expressly authorized to do so. You can disclose to the client's reps, or the people in the law firm. And one thing that I thought was interesting here is except when otherwise instructed by the client. So if a client comes in and says, don't tell anybody else in your whole firm. Now, of course, I'll have to say, I can't keep it 100%. You know, the lawyer would have to, there'd have to be some people, other people working on it, right? That administer the staff and so on. But if the client says, I don't want any female lawyers knowing about this or something, then, you know, you have to follow the client's instructions, basically, is this rule that it has that carve out. Lawyers may reveal confidential information when the lawyer has reason to believe it's necessary to do so to comply with the court order or with the rules or other law. And of course, a lawyer can do so when there's a controversy to establish a claim or defense, when there's controversy between the lawyer and the client. Now, if you remember, it said E and F, you are allowed to disclose. E, I didn't put it on the screen, but in the PowerPoint, but it says when a lawyer has confidential information clearly establishing the client is likely to commit a crime, a criminal or fraudulent act that is likely to result in death or substantial bodily harm to a person, the lawyer shall reveal confidential information to the extent revelation reasonably appears necessary to prevent the criminal or fraudulent act. So we not only can, we must reveal if there's that kind of threat. And then the other one is shall reveal information under the rule on candor towards the tribunal. Okay, so in this scenario, when Jones is talking to the buddy at the holiday party and says, I've got this conflict and I don't know what to do, I didn't tell anybody, is this particular breach malpractice, legal malpractice, or is it a breach of fiduciary duty? Well, let's take a look quickly at that, because I see my time is getting a little close. So I didn't know about this for a very long time, but the law in Texas is really clear that negligence is wholly distinct from breach of fiduciary duty. And plaintiffs, sometimes the lawyer, if the plaintiff missed the statute of limitations on a negligence claim, they'll try to turn it into a breach of fiduciary duty claim when it's really a negligence claim because they have different statutes of limitations, or when the lawyer thinks there's a DTPA claim and wants to get treble damages, the lawyer will try to turn a negligence claim into a breach of fiduciary duty claim. And this is called the anti-fracturing rule. You cannot convert a claim for negligence into fraud, breach of contract, breach of fiduciary duty, or DTPA. To distinguish which one is which, professional negligence or malpractice is a claim based on the quality or adequacy of representation of the client. You give bad advice. The lawyer gives bad advice. The lawyer misses deadlines. The lawyer fails to do discovery. Breach of fiduciary duty, on the other hand, is a claim involving the integrity and fidelity of the lawyer. Are you being loyal to the client? Examples of breach of fiduciary duty are an undisclosed conflict of interest, such as with Attorney Davis, or keeping a retainer that was not earned. I have brief mention of it here, but we'll pass it on to Gabriel in just a minute. I found a Forbes article from January 2023 online that had some very interesting perspectives. I'm not sure that everything it lists as malpractice would not be breach of fiduciary duty instead. But in the interest of time, I will pass it over to Gabriel in just a minute. One more other thing I want to say, sort of substantively, is here are two resources. Anybody who does not know about either of these, please write them down, take a screenshot. Texas Center for Legal Ethics is an independent nonprofit. It's legalethicstexas.com. They have a gajillion legal opinions that are based on scenarios, but of course, specific facts changed, that will give you a lot of insight. I found one on a webinar, what a lawyer can say and can't say during a webinar. And this is the November 2024 ethics opinion of the month. They're always in the Texas Bar Journal. State Bar of Texas has a toll-free ethics helpline, 1-800-532-3947. I have used that myself. Staff attorneys available to answer questions. It is not confidential, but they are more than willing to help and are a very good resource if you're in a bit of a dilemma. In closing out, for my part, I'll just say thank you for being here and the privilege to speak on this important topic. And with that, I will turn it over to Gabriel Garcia Gonzalez.
Well, hello everyone. Yeah, my name is Gabriel, and I am I'm a new attorney. I graduated from South Texas College of Law in May of last year. I took the bar, and I've been working at Thompson Co. with Kamy and Daniel. And as a new attorney, every day is a learning experience, and every day I have questions. So I kind of created a couple of discussion questions to sort of, to see, as a young attorney, I feel that I have every day. So let's see if I can get this. So am I sharing do you see the PowerPoint? Okay. Because I can't tell. So are the questions on the screen right now? Okay. So the first question to sort of throw out is that, well, as a new attorney, it's been just a big change from having a law school schedule to a regular working attorney schedule. And as such, learning time management skills are crucial. So what are good ways to be accountable for one's time and deadlines, and in order to avoid mistakes for the clients and provide competent representation?
Kamy, do you want to answer that, or do you want me to take that? Okay. So, in a litigation practice, the most important thing is finding some way that works for you. There's plenty of different ways that different people find. Some people make magic use of the Post-it system. They will get in a DCO, they will just write down all the dates from the DCO into the Post-it. They'll put it by their laptop. That works for them. I like having an electronic calendar. That's what works for me. Just because it works for me doesn't mean it's going to work for anybody else. But I enter all the dates in the electronic calendar. That way I can look at it during the middle of the deposition and just see what I have coming up tomorrow, the next day, next week. So I mean, I think what is important is to just talk to more senior lawyers that you're working with. Or, if you're a solo or just in a small firm where you don't feel like you have somebody you can talk to there, you just want to go out and find mentors, talk to more experienced people. see what works for them, try it yourself. The most important thing is just having a system that works, because a system that works for me may not work for you. But the last thing you want to do is just an unforced error. You miss the date to designate experts. That's a call your carrier situation, something that could have been avoided if you had calendared that either on the post-it system, on your phone, or some other way.
I do both. I don't know if people can you hear me?
Yes.
Yes.
Yeah, so I keep an electronic calendar, and right now on my wall that I face, I have a list of trial settings that's just handwritten that I update as I go, and I keep a printed out copy of DCOs as well, because you never know, something may get missed or deleted on accident, or Outlook could get a virus or who knows what. So I personally recommend both, or I do both, written and electronic.
All right. So another question that I've had is, well, I mean, first off, I've been very fortunate that my firm has provided me with mentorship opportunities and experiences. All my coworkers are all very open to help me. But how important is it for a young attorney to be able to rely on more experienced mentors and coworkers that know what they're doing more than the young attorney?
So it's incredibly important to have that kind of support system, support structure, as you make the transition from law student to, junior litigator, and then as you start trying to continue to build your skill set. So yeah, that it is critical to have somebody that you can look up to. It doesn't necessarily need to be at your firm. Sometimes it can be a mentor at another firm. Everybody's coming from different firms, different situations. So uh, but yeah, in terms of my career growth, I think that has always been essential. That's what I look back on over the years, just having access to these high quality litigators that I really looked up to and admired. And like as an example, before the pandemic, I worked with Erin Lunsford, former judge, 61st. I worked with her every day. Our offices were literally next to each other. She was double board certified, one of the best litigators probably in the country. And I worked with her on cases every day, and I was able to go into her office and we just talk about things. And I became a much better lawyer just because I had access to a former judge, a double board certified lawyer, somebody I really looked up to and admired. So yeah, that kind of thing is critical. You don't necessarily need to work together. It can be outside of your firm. If you're a part of affinity groups that are in the community, specialty bar organizations, you can meet people through a variety of these different ways. And I think that is just a great way to kind of figure out what kind of lawyer you want to be and start taking concrete steps like that. So, and the other way, if you're a more experienced lawyer, I would highly recommend, you give back. If you benefited from having that kind of mentor, take somebody a little younger under your wing and just kind of do the same thing for them that the more experienced lawyer had done for you. Yeah, so highly recommend that. If y'all are showing up, you're probably already part of the HYLF community. So there's a lot of ways to find kind of a mentor, somebody like that. If you're interested in this practice area, reach out to me. I'm more than happy to talk to you about how you should find a mentor. Yeah, and then definitely people you work with are a great resource. I'm very fortunate to work down the hall from Kamy, who has a lot more years of experience than I do. And then same with my partners here at the firm. There are hundreds of years of experience up and down the halls. Another person I go to frequently, another partner here, Corey Reed, he has much more trial experience than I do. So he is vital when I have questions about certain trial things. So that is an excellent question, Gabriel.
All right. So another question is, the word sanctions can be intimidating. So how can a young attorney avoid sanctions or any disciplinary matter?
I can respond to that. For one, know the rules. And not just the Texas rules of civil procedure, know the local rules. know the Texas disciplinary rules of professional conduct. We all took I think it's called MPRE, had to pass that. Probably most lawyers took professional responsibility in law school as well, but just don't underestimate being familiar with those. Another thing I would say, and that I had thought about was in preparing for this presentation, I pulled up the Texas Lawyers Creed. If you guys haven't looked at that in a while, it's a little archaic, some of the language, but it's well worth reading. Just remind yourself of what we really do and where our loyalties really lie to our clients and candor to the court and things like that. Know the rules, know the case. I don't think knowing the rules is necessarily more important than knowing the case, but if you follow the rules, chances are you're going to be in good shape to avoid sanctions. But know your case too. I was threatened once with being sanctioned by a court in not Harris County, out in an outlying county. And the reason was beyond my control, somebody was in my office was not cooperating with presenting a witness for a deposition. It was very miserable to be threatened like that. The judge said, if you don't present them whatever day it was the next day, you'll be sanctioned. So do your best to be cooperative and be reasonable also. We all have obligations to act in good faith. And that's really the reason I bring up the Texas Lawyers Creed is if the lawyers I had worked with were really following the Texas Lawyers Creed and all the different rules, then perhaps I wouldn't have been threatened with sanctions. I don't know. But it is a frightening area. But if you're diligent and you know the rules and you know your case, then you stand a much better chance of avoiding sanctions
And
disciplinary actions.
Well, and not to repeat myself too much, but first step should probably be go talk to your mentor, your supervising lawyer. Somebody that has just more experience than you, because you're going to want an opinion. It's very easy for the other side to file a motion for sanctions. It takes 20 seconds to write up something like that. Whether you're actually in trouble is something different, and into how you prepare yourself for the hearing. If you work in a larger firm, probably a more experienced lawyer is going to go with you to the hearing and argue why sanctions are not appropriate. That's again just saying rely on your support network. Don't just immediately freak out and feel like you're all alone and nobody else is there to help you and you're going to get disbarred and all this bad stuff's going to happen. Everybody who has practiced in litigation, especially in the Dallas area, long enough, you have been either threatened with sanctions or they filed a very frivolous motion for sanctions against you that's going to get swatted down the minute you get to a hearing. So yeah, you are in good company if you're worried about sanctions. It happens to all of us. Just talk to somebody for perspective that is more experienced than you. They will help you through it. They will give you advice. If you're in a big firm, there's probably a general counsel who is the person who's going to help you with that. But, if you talk to your senior associate, your partner, or whoever, they will just make sure you get to the right person to actually help you through that.
One other quick comment on that. For anybody who's experiencing unusual stress, make sure you check out TLAP. I'm putting the website, Texas Lawyers Assistance Program, in the chat. If you need the website, it's right there, tlaphelps.org.
That's an excellent point. The practice of law is not easy, and I don't know anybody who thinks it is. So the TLAP is a great resource for people who just need to have some extra assistance.
All right. Following question is, how important is to have good, thorough legal research? Another fear that a young lawyer I've had is submitting a motion or something to the court with just the wrong law. So how important is the research? And if a mistake is made, how can that be fixed?
I would say it's super important that you do the research. If you it's the age-old thing from law school, shepherdize, do your site checks. I'm not sure what's available through the Texas Bar. I know we have Fast Case, but I don't know what site check program or feature it may have. But if there isn't one, especially if it's an important motion, summary judgment or something like that, spend a little time, go to the library or check out other online resources to get that case. You can kind of do Schiffer sort of on your own by searching for cases, citing that case, putting in the citation 313 Southwest 3rd, 542, something like that is better than nothing.
Right. Yeah, this is an absolutely critical area in litigation. Once you lose your credibility, it's gone. I mean, this is something that everybody should just have in the back of their mind, double check things that are important. Where we started the presentation talking about AI generating fake sites, fake law, all that stuff, and there being real consequences. I mean, the same thing works if you're just copy pasting something that you got off of Google, even if it's you typing it, not the AI program typing it. You still need to actually read what the underlying case law is and make sure you're actually representing what it is to the court. So yeah, this is a critical component of litigation, and I mean, you never want to see anybody make a huge mistake, but yeah, this is one of those things that is easily fixed by just spending the time to research, spending the time on Westlaw or whatever program you have.
All right. And then just a final question that I have is that now that I'm as a new attorney, I'm finally getting used to this new schedule post law school, and I want to start to find the time for more networking opportunities. So how important is networking, and how can you find time for it?
So I think networking is critical and probably one of the most important things that we do as a lawyer. I think that that's one of the things that has helped me most going from, law school into young lawyer to a whatever you would call me at 15 years of practice at this point. I mean, it's critical to meet people out in the community, a variety of different perspectives, different backgrounds. In our practice area in professional liability, I mean, you're going to be meeting potential and future clients. It is important to, put the best version of yourself out there and introduce yourself, have your elevator pitch about what you do for your day job. If you have time to spend with nonprofits, volunteering, volunteering with food banks, stuff like that, include that as part of your, 30-second elevator introduction to yourself. Yeah, I think that's critical. That's where you're going to meet your mentors. That's where you're going to meet opposing counsel. And yeah, so I highly in favor of networking. I joined some affinity groups that I was a part of. I thought that was a great way to meet other people kind of similarly situated, with a somewhat similar kind of background demographic. I've joined some other ones that maybe have some more kind of common practice interests. I'm a member of one of the big national ABA ones for legal malpractice. I mean, that's a great way to meet your subject matter experts, people that, you want to be in 10 to 15 years of additional practice. And yeah, it's a way for you to also just kind of become a part of the community. A lot of these kind of bar organizations or other groups that I'm a part of, we will do charity walks. We will go volunteer at the food bank together. It's a way to just kind of integrate yourself into the community, meet different people, have different experiences, and just kind of get out of the office for a little bit. Billable hours are always important, but there is such a thing as work-life balance where you need to kind of feel motivated and energized, and networking and just meeting people, getting out of the office. I think that's a great way to do it.
I'll just add that if you're not familiar, there are a number of lawyer organizations. It's not just American Bar Association and the Houston Bar Association. They're great, but there are also a ton of other options here in Houston. There are some that are specific communities, like I think there's the Mexican American Bar Association. There's Inns of Court. I'm in an Inn of Court that I really enjoy very much, where I've been to judges' houses, and I know them, they know me. It's a great thing to walk into that courtroom, having that background and having that personal sort of connection. I don't get favoritism, obviously, but it's just a nice thing to be able to walk into the courtroom. And when you do these networking events, if you meet opposing counsel, you might have a bit of a different relationship with that person than you would if you never met them, because we all know the email can sometimes not come out the way we intend, or can even come out the way somebody intends, but it's not exactly professional or civil. If you meet that person at some networking event, it might be different. They might have a different approach to communicating. I just think it's essential for those kinds of purposes too. And just don't give up if you go to one or two and it's just not your thing, find another one that is. Just continue to look, because there are loads of options. There's sections in the state bar has different sections that you can go to meetings. The Houston bar has sections. There's HYLF, obviously. There's a number of different organizations that you can get involved with to get you some interaction in the community so you can network.
All right, well, thank you very much. That rounds up my questions and my young lawyer questions. So thank you for answering them.
Yeah, excellent questions. Anybody have closing thoughts?
Thank you for the presentation.
Thank you, Lucy. We appreciate everything you did to get this set up for us.
Yes.
Well, I want y'all to stay on so I could do a photo for y'all three.
Okay.
Perfect. All right. Well, everybody else, thank you so much for joining us here today. We really appreciated you spending time with us. Hopefully you got whatever you were looking for out of the presentation. I know that Kamy, Gabriel, and I really enjoyed presenting this to y'all. If you have any additional questions, you want to talk about professional liability in general, you want to talk about what bar organizations we like getting involved with, anything like that, just give us a call, email. Yeah, we would love to continue the conversation with y'all. All right, well, thank you for joining. Hope you all have a great rest of the day, and hopefully we will see you at some more of the HYLF and HYLA CLEs over the rest of the bar year.
Thank you, everybody.
And Stacy, it was great seeing you too. I mediated with Erin yesterday, so she says hello as well. Yeah, Lucy, could you help us
Yep.
look good?
Yep. Oh, you're always look good. Okay, so we're gonna